Congratulations. Program Director, I trust that you have kept to the time allocated. Thank you very much.
Let us give another hand clap for the chair and the presenter. My Lord, the Chief Justice, let me also take this other chance to inform you that we have been joined by Justice Harrison Mutabazi, representing the Chief Justice of Rwanda. You're most welcome, my Lord. I also wish to take this opportunity to introduce the team from Botswana. We have Honorable Justice Michael Mothabi of the High Court of Botswana. My Lord, you're most welcome. He moved with a team which includes His Worship Sofaone no Moreng. I hope I've pronounced it well. Thank you. My Lord, I'd like to ask you may take your seat as we invite the second chair of the session. Let us give them a clap as they take their seats. Our next chair of the session is Honorable Justice Chan-Rick Madut, Paul Pin, the Honorable Chief Justice of South Sudan. My Lord, you're welcome to take up your seat. We have also been joined by Commissioner Nora Matovu. I've seen her somewhere at the extreme end. Commissioner, you're most welcome. Thank you, my Lord. My Lord, you may use that microphone. My Lord, I invite you to take up the microphone and invite the team. Thank you, my Lord.
Good afternoon, my brothers and sisters, with all your protocols observed. In the interest of time, let me just call upon the following to come up here so we can go ahead with our session. That is Honorable Justice Professor Joel Ngugi, the Judge of the Court of Appeal of Kenya. And I am also calling upon Honorable Lady Justice Jane Okuwa, and the Pepperdine team. Please come up and we continue this.
Honorable Chief Justice, all Chief Justices, ladies and gentlemen, good afternoon. I just used high context culture to know I'm supposed to speak now. I will skip the protocols with your permission because of time, and I will try and keep this as short as possible. I know it's just before lunch. This is the most dangerous time to speak. But we will try and keep it engaging. I hope I can be heard at the back. Professor Singh, can you hear me? Thank you. All right, so I am just going to spend the next few minutes talking about our efforts to mainstream alternative justice systems in Kenya. And I will begin by asking a question that confronts us many times as people in the legal field, which is, where is justice found? Where is justice found? As you think about that question, you could also think about the analogous question, where is health found? Or where is knowledge found? Is health found in hospitals? Or knowledge in schools? Now, for those of you who are immersed in the history of the ADR movement in the United States, they would recall some echoes of these questions from a famous article written by Professor Mark Galanta, an emeritus professor from Wisconsin Law School. And this is what he says. If you can please go to the next slide. I don't know if this one works. It does work. If I can have my PowerPoint, please. There you go. So this is what Professor Mark Galanta says. Just as health is not found primarily in schools or knowledge in hospitals or knowledge in schools, so justice is not primarily to be found in official justice dispensing institutions. So what this essentially means is that whereas we work in the courts, it is probably a misconception to think that justice is found in the courts. Just like you don't find anybody walking to the hospital and saying, I am going to find health. In fact, you are walking to the hospital in itself is an indication of deficiency in health, so it is with justice. And the point is, Africans in general, and certainly Kenyans in particular, have a particular affinity to this conception of justice and where justice is found. In fact, one may say that Africans generally, and Kenyans in particular, do not think about health, about justice in its absence. They don't think about it in terms of its deficiency. They think about it in terms of its presence, in terms of its quotidian, omnipresent, in its everyday affairs. That is how Africans generally think about justice. But this is a conception of justice that we seem to have missed as we transitioned from our traditional justice systems to the borrowed systems that we use, be it common law systems or the civil law systems. Now, fortunately for us in Kenya, as Kenyans were writing the Constitution in 2010, they had an occasion to re-engage this conception of justice and to try and go back to the African conceptions of justice. And they did this in a rather complex but interesting way. They did this by including in the Constitution Article 159(2)(c) of the Constitution. And essentially what that article says is alternative forms of dispute resolution, which I am calling alternative justice systems, shall be promoted. Now it's important to understand the context of this constitutional provision. And I'm just giving you a little bit of a background to understand the imperatives for Kenyans to mainstream alternative justice systems. Now, the constitutional schema in Kenya is such that it starts at Article 1, where, which is a sovereignty clause in the Constitution, where Kenyans declare themselves, the people themselves are the sovereign. But as sovereigns, they delegate judicial authority to the judiciary. That is in Article 1 of the Constitution. But when they come to Article 159(2)(c) of the Constitution, the people, who are the principal, who have delegated their judicial authority to the judiciary, now give the conditions upon which the judiciary will exercise that delegated authority. And one of the conditions that they give quite explicitly is this, that alternative forms of dispute resolution shall be promoted. Now, it's important to understand that in constitutional lingua, this is mandatory language. It's obligatory language. What Kenyans are telling the judiciary is they are commanding the judiciary to promote alternative justice systems. Now, it's important to understand that this is also supported by other articles of the Constitution, for those of us who think about holistic reading of the Constitution. If you go to Article 10, it talks about public participation, including in the justice sector. If you go to Article 11, it talks about culture, which we've just heard a lot about from the lecture by Professor Singh, culture as the foundation of the nation. I believe Kenya is one of the very few countries that has that in the Constitution. And then we go to Article 44, it talks about the right to culture as part of the Bill of Rights. So if it is part of the Bill of Rights, then it means for it to be derogated from, then you must do an analysis of why it's compelling and justifiable for you to derogate from that, since it's in the Bill of Rights. Now, the right to culture includes the right to resolve disputes according to one's own culture. So, hence, if it's defined that way, it means that the right to resolve dispute through alternative justice systems becomes part of the fundamental rights of all Kenyans, which the judiciary cannot take away. And that's the reason Article 159(2)(c) is framed as it is framed, giving a commandment to the people, to the judiciary, to promote alternative justice systems. Finally, we have Article 48 of the Constitution, which is also in the Bill of Rights, which assures access to justice. In a minute, I will demonstrate why Article 48, purposively read, must include promotion of alternative justice systems. So then we have in the Constitution a commandment by the judiciary to the judiciary that it must promote alternative justice system. And one of the questions that the first Chief Justice of Kenya in the post-2010 Constitution faced was, what does this mean for the judiciary? What does it mean for the judiciary for the Constitution to say you must promote alternative justice system? What the former Chief Justice Emeritus Willie Mutunga did with that question was to form a task force, the Task Force on Alternative Justice Systems. And the main mandate of that task force was essentially to unbundle what it means for the judiciary to be commanded to promote alternative justice system. So I was privileged to chair this task force. And what we did is, instead of engaging in an archival research or brainstorming sessions and so forth, what we decided to do was to approach it through an anthropological pedagogy. We traveled throughout the country. We observing what people were doing with the questions of justice. How are people resolving conflicts that arise in their own communities? What do they think about this clause in the Constitution that commands the judiciary to promote alternative justice systems and so forth? Now, what I want to present to you next, because of time, is really, I've called them 6, but actually there are 8 findings that we came up with from this task force, which became a policy that we now call the Alternative Justice Systems Policy, which was launched in Kenya in 2020 by Chief Justice Emeritus David Maraga. I'm quite honored that he is in the audience today. So by the time we were presenting this, Chief Justice Mutunga had left, and Chief Justice Maraga was the Chief Justice. This became the Alternative Justice Policy, and has now been embraced by the current Chief Justice, Martha Koome, in her blueprint for the judiciary, sustaining judicial transformation through access to justice. Now, the first thing that we found was that alternative justice systems reflect the lived realities of an overwhelming majority of Kenyans. But of course, that is something that we intuitively know. We know most of our people decide their cases or find justice through alternative justice systems. But it was good to have actual quantitative confirmation to that. And this is what we found, and this somewhat reflects what the Chief Justice of Uganda said in his speech. When faced with a grievance or a conflict, Kenyans do the following. 19% of them do nothing. Nothing. So it's what the Chief Justice said, they resign to their fate. It is what Christians say, they go to the book of Romans chapter 12, verse 19, that says, the vengeance is mine, says the Lord. So you just leave it to the Lord. If you are Swahili speaking, you say, Mungu hali ugali. God does not eat ugali, so I just leave it to him. He'll take care of it. That's 19%. It's a frighteningly big number. Only 17% go to court. And 64% go to AJS. Now, the next finding is important, even as we think about the intersection between AJS and ADR. Now, what we found was that this affinity for AJS actually mainly reflects entry factors rather than exit factors. We usually explain people going to AJS by saying our courts are clogged, our courts are unfair, they do this, they are bad, so people are actually exiting the formal justice system to go to the AJS. What we found is, in fact, the reality is people have a preference for alternative justice system in the first place. It is not that they are exiting the formal court system to go to the AJS. It is that they have a definitional preference for AJS. And why do people go to AJS? If I asked all of you in this room here, each of you can give me a reason, and we can have as many reasons for why people go to AJS as the people in this room. From the fact that it is faster, it has less formalities, it is less formal, it has a preference, a philosophical preference for the truth, as the speech by His Excellency the President said, and it has creative solutions which are not available in the justice system, and so forth. And so in very many kinds of cases, it provides superior justice to the justice that we can give in the formal courts. And that is not dissing the formal court. That is not saying anything bad about the formal court. It is just saying it is a different kind of justice that is optimal for certain kinds of cases. And in this, I'll just give you one very short story. We established the Alternative Justice Systems Court Annex in Kajiado County in southern Kenya in 2021. Among the first cases that was, the very first case actually, that was brought to that system was a case that had been in the court system for 32 years. It's a real case. Was filed in 1992. Now, the interesting thing about that case is, usually, the person who tries as much as possible to delay cases, uses all the tricks in the book, all the civil procedure tactics and techniques to delay cases, usually, they are the person who think they are going to lose. Is that not true? For those of you who are lawyers, right? If you know you are going to lose, then you try everything possible. In Kenya, we say you grab someone's land, you build on it, and you delay the case for 12 years, it would have returned what you invested, and then you can leave it. You can lose, by that time you would have lost your case in the Court of Appeal, and the land can go away, you've already reaped enough, as long as you got the first injunction. So in this case, however, the person who went to court was the person who had a title to the land. It was a piece of land used mainly for ranching in semi-arid area, which was 50 acres. The defendant occupied a very small part of the land, was in occupation of about 2 acres of the 50 acres. The plaintiff, who had the title, tried everything under the sun to make sure that that case would never be heard. The defendant, who did not have a lawyer and was a widow and was poor and was self-representing, was very anxious for the case to be heard. But the plaintiff, who had the title, who could possibly win the case and had a lawyer, did everything to make sure the case would never be heard. So when AJS system was introduced, he was the first man to go to the AJS system. That case was resolved in a day, actually in an afternoon, in the AJS system. When they went to the AJS system, it just turned out, first of all, the elders in that area knew exactly what had happened. In the subdivision of lands, from the group ranches to individualized lands, the brother to the plaintiff was one of the group ranch officials, was a counselor then in Kenya, educated, had money, influential. And what he did was he took the brother's land, which was 50 acres, and then he arranged for the brother to get 100 acres, part of which belonged to the widow. And he hoped his brother would be happy. At least he has 100 acres instead of 50 acres. And arranged for him to get the title. The elders had this story. That case took less than 2 hours. They just went and they sat and they decided, go call your brother. And the brother was called and he was told, you go bring the title, you know what you did. Turn over the title, case resolved. Title was, they gave the minister the decision to process the titles, 50 acres for the widow, 50 acres for the plaintiff. When we went to give the titles to this land, because it was a very fast case that was being done under this system, this old man said something that I will never forget as a judge and as a lawyer. Because he said, thank you so much for saving us from passing on a curse to my children. Thank you. Because if I had gone to court, I would have won this case. And if I had won this case, then I would have had to subdivide this land to my sons. If I had subdivided this land to my sons, in our culture, I believe I would have been passing a curse to them up to the 7th generation. Because that is the curse you get when you steal land from a widow. but he was sure he was going to win in court. Meanwhile, his sons kept asking him, so we asked him, why did you then go to court? And he said, because my sons kept asking me to subdivide the land to them. The only answer I had for them was the case is still pending in court. Therefore, I cannot subdivide the land to you, because I knew if I subdivide the land, I will be passing a curse to them. So I was just kept fervently hoping that one day a system will come where the truth will come out, because I was not in a position to face my brother. When was the last time as a judge a litigant said, thank you for saving me from passing a curse to my son? I will bet not many times. That is a story about the optimal superiority of the alternative justice systems for certain kinds of cases. It has nothing to do with the inferiority of the formal justice system. It just has something to do with the justice system as it exists. So I thought I should tell you that story as an illustration of the affinity for entry factors that our people feel about AJS. The third thing we found was that, remember the 19% of Kenyans who do nothing when faced with a legal issue? That is what SDG 16 calls the justice gap. That is the justice gap that we need to bridge, basically. These are the people who have no access to justice. And we know from the literature in law and development that we will never get sustainable socio-economic development until everybody has access to justice. And 19% is a big number of people without access to justice. But the point is, if we try to channel all these 19% to the formal court system, the formal court system will most surely collapse. The formal court system is not where the 19% belong. In fact, I told you, the 17% of Kenyans who come to the court system, we have been unable, as a judiciary, to deal with the number of cases that are filed before the court. I heard with a lot of envy that in Uganda you have a backlog of only 50,000 cases. That seems like a dream to us. In our last State of the Judiciary address, the Chief Justice told us in Kenya, we have 350,000 cases as backlog in Kenya. 350,000 cases translate, we have about 700 judges and magistrates in Kenya. That translates roughly to each judge and magistrate in Kenya having 500 cases as backlog. So you think about that. So every time I see a candidate for Chief Justice, including what Justice Maraga did when he was being interviewed, telling us, this is how I'm going to end the backlog, by making sure the judges write faster judgments, by making sure they work longer hours. For my TV set, I always say, uongo. That's a lie. It will never happen. The truth is, we will never clear the backlog if we keep doing the same thing that we have been doing. That is the truth. We will not clear this backlog if we continue channeling. Now we're talking about access to justice, SDG 16. Let's bring more people. Let's bring access to justice to more people. Let more people file cases and so forth. We can't deal with the ones that have been filed. We will be unable to deal with it. So the best place these cases need to go is, most of them need to go to the AJS system. Luckily, we find that most of our people understand and actually prefer that as their method of dispute resolution. So the anxiety that sometimes lawyers have, the anxiety that, maybe the AJS system is an inferior form of justice because, they are not as learned as us. They don't wear horse hair on their heads like us. They don't wear crimson robes like us. They don't speak Latin. They don't say res judicata and ipso facto. So maybe the justice they receive is less superior. The truth is, the justice seeker has no such anxiety. That anxiety is a virus that was planted on us by the first lecturer who lectured you in law school in first year. It does not exist among the justice seeker. All they want is a forum for resolution of their dispute. And I think that is really good news. So as far as I'm concerned, in Kenya, and I believe in many African countries, AJS has already been mainstreamed by the Constitution itself. The only question is, how do you animate that mainstreaming in terms of the operations of the judiciary? So to answer that question, one of the things that we needed to figure out is, how is AJS practiced? Because it was important to map out the typologies of AJS. And we found 4 different ways in which people practice AJS or seek justice from AJS. And the important thing about this list of 4 is that it is not teleological in any sense, and it is not hierarchical in any sense. There is no expectation that one will, over time, evolve to the other or to be more like the court and so forth. They are just as good as they are. So to quote the Bible, as the Bible tells us, come as you are, so it is with the AJS system. They are good as they are. The first one is autonomous AJS mechanisms. These are autonomous. They are not affiliated to any government agency or any civil society. They just do their thing. They just resolve their disputes organically, most of the time using organic customary law in the spaces. But some of them we found are also religious in nature. Some of them are in the estate. They just resolve disputes. And they do it every day. And they resolve a lot of the disputes that come up. The second one that we found very interesting to start paying attention to is what we call third-party state-based. These are people who we don't necessarily think as judges or as arbitrators in their day-to-day disputes, but every day they sit and they decide cases and they resolve disputes which do not reach courts. So in Kenya, we think about the assistant county commissioners, the chiefs, the labor officers, children's officers, and so forth. Almost always, they resolve a case or two without much ado. Then we have third-party non-state-based. These are usually civil societies that provide a forum for parties to resolve disputes. And then lastly, in Kenya, we found in the last 10 years, we've had courts that have found a way of hybridization of the alternative justice systems and the court system. So they sort of annex the alternative justice system into the court system so that they refer certain kinds of cases into the court systems. And we have a number of examples of how that has worked. The sixth thing we found about this, which is really interesting, is we've talked about culture, and one of the anxieties people have about alternative justice system is, does this mean going back to culture as it existed at the reception clause in 1897 in Kenya? I don't know what the reception clause was in Uganda. Is that what we're talking about? Does it mean that we go and resurrect Eugene Cochran and find what the restatement of African customary law means and so forth? But what we found in practice is that the culture that people practice in AJS is actually a very dynamic culture. It is not my grandmother's culture or great-grandmother's culture. It is a dynamic culture, and in fact, most of the time, the source of law they use, you'll find, is actually quite dialectic. They get their sources of law from statutes, Bible, Quran, culture, traditions, and so forth. Then finally, penultimately, the seventh thing that we found is we now unpacked what then duty to promote must mean for the judiciary. Remember, promote is a language that is used at least in our constitution. What does it mean to promote AJS? And for us, we found that it means 3 things. Number one, it means to respect AJS mechanisms. Respect means do no harm to AJS mechanisms. If you find that AJS mechanisms are deciding cases, don't call them kangaroo courts. Don't speak about them in language that is pejorative. If they are working, they are not broken, don't fix them. Just leave them alone. Respect them. The second one is protecting AJS. Protecting means you protect third parties from harming AJS. This is usually a threat by different government functionaries who try to channel a dispute resolution only within certain channels in the government or within the judiciary. And that appetite, I call that an imperial appetite. That imperial appetite towards dispute resolution, we find that is unconstitutional. But lastly, and importantly, we found that the duty of the judiciary includes the duty to transform. The duty to transform AJS mechanism, which must include the duty to transform certain cultural practices within AJS. If we had more time, we'll speak more about that duty to transform. But lastly now, and number 8, this triple duty to us means for the judiciary, and this is where I am just whetting your appetite, I'm just planting some of the things that are now contained in our AJS policy, which I welcome you to read. I'm going to make an electronic copy available. It means at least 3 things for the judiciary. First, a human rights approach to AJS is possible, and we can talk about that if we have a plenary session. What we found out and what we explain at length in the policy, and which must be one of the pillars of mainstreaming AJS in the judiciary, is that it must be human rights-based approach to AJS, and it is possible. And one of the first things that we must do is to decolonize the human rights discourse as it is currently practiced. But secondly, it also must mean that the judiciary must develop appropriate doctrines of interaction. By doctrines of interaction, I'm referring to the doctrines that are used when AJS intersects with the formal court. An example would be if parties have gone to an AJS mechanism and a resolution has been reached in the AJS mechanism, and one of them defects later and comes to court, then how should you deal with that? Those of you who are arbitrators or mediators know that we already have certain doctrines of interaction, which in the case of arbitration is statutory on how the court deals with it. So in this case, they must be judicially created doctrines. And then lastly, the judiciary must develop an appropriate jurisdictional doctrine of AJS. In the case of Kenya, we found the appropriate doctrine of jurisdiction is the agency theory. The agency theory of jurisdiction is the one that aggrandizes the autonomy of individuals while at the same time taking seriously the duty to transform as a human rights imperative. So what that theory basically asks is just 2 questions. Number 1, are the 2 parties who want to go to an AJS mechanism, this we call the positive test, did they, as an objective matter of their own volition, choose to be in an AJS forum? If the answer is yes, then you proceed to the second test. If the answer is no, the inquiry ends. Those parties cannot be in an AJS mechanism because the Constitution has provided the courts as the default mechanism. But if the answer is yes, you go to the second test, and the second test is a negative test, which simply asks, is there any statutory text or spirit, or statutory text or spirit, or compelling public policy that militates against AJS taking jurisdiction in that particular matter or in that particular issue? If the answer is no, then that is an appropriate matter to go to AJS. Be it civil or criminal. Be it a small matter or a big matter. Be it a complex matter or a simple matter. It would be an appropriate one to go to AJS. Thank you so much for your kind attention.
Our next speaker is our beloved mother, Lady Justice Jane Okua. When she's through, of course, there are other members of the paper drying team, that is Professor Cameron McClum, and then we have Mr. Scott Leist and Mr. Alan Collier. Now I call upon Lady Justice Jane.
Yes, please, I My Lord, the Honorable, the Chief Justice of Uganda, and all distinguished participants, I join my colleagues to beg to stand on the protocol that has already been adopted. All right, thank you so much. I will speak to mainstreaming alternative justice systems in Uganda, but with a focus on plea bargaining as an initiative in the criminal justice system. I will say a few words as an overview, and thereafter my colleagues and my friends from Pepperdine will say something else, again in respect of plea bargain. By way of introduction, Uganda's criminal justice landscape changed drastically in 2016 with the passing of the plea bargain rules, statutory instrument number 43 of 2016, that was made by the Rules Committee established under Section 41 of the Judicature Act, Cap 13. The committee that worked on the rules is headed by the Honorable, the Chief Justice of Uganda, and the committee is empowered under Section 41 of that statutory instrument to make rules for regulating the practice and the procedure of courts. Now, the rules on plea bargain apply to all courts of judicature, and they allow the accused person, the prosecution, and a victim of crime to work out a mutually satisfactory disposition of criminal cases subject to court approval. The justification for plea bargaining, I think, is best painted by Justice Yorokamba Mwine in his book, Plea Bargaining in Uganda, Law, Procedure, and Practice. And he highlights what the situation was like in 2016 when the rules came into force. That was actually April of 2016. The number of cases was very high, 52,221 cases pending in the system, as confirmed by the National Court Case Census that was carried out that year. And backlog of cases, greater prison crowding, overcrowding was the norm. Now, although the basic colonial infrastructure was designed to imprison about 3,000 people, at that time in 2016, the inmates were 293.1% over. So that paints the picture of what we had. But above all, the question of delayed trials, long periods on remand, and persons being held in pretrial custody for anywhere between 8 months to 6 years. That is how long, 8 years, before a capital offender would find his way to a courtroom to face trial. The plea bargain rules are majorly modeled on the US system and their experience of plea bargain. They were developed with the assistance of Pepperdine University, which has been instrumental in its rollout and its implementation. But the whole process started with a pilot project where some cases were assigned, judges were identified, prosecutors were identified, and the cases were plea bargained. And lessons were taken from that. One, from the pilot, it was clear that plea bargain demonstrates a higher acceptability of the outcome by all parties, therefore a satisfactory disposal of cases. It had the ability to address backlog and prison congestion, and lessons were picked. There were also benchmarking visits to the US where it was established that they plea bargain over 95% of the criminal cases that they have. So plea bargain as an alternative dispute resolution mechanism, it changes the scope of criminal practice in Uganda because many of you who handle criminal cases know that the victim in a criminal case oftentimes is relevant for the purpose of his or her evidence. And after they have given their evidence, they leave the system to decide what else happens. They have little influence with the outcome of the case, and a lot of times their interests are not considered in the sentencing of the accused person upon conviction. Now, plea bargain comes in a system, formal criminal justice system, which is retributive in nature. It focuses on punishment of offenders and the need to prevent crimes and maintain order and to deliver justice to the victim and the community at large is hinged on the seriousness of the penalties and the concept of punishment other than forgiveness and other aspects. So this retributive nature, rather than the restorative process, is what shapes our formal criminal justice system, which is also highly adversarial. We have seen parties appear in courts and the process is aggressive, the process is hostile between the accused and the victims, each trying to advance their theory as being the correct one. It is an unfriendly atmosphere that does not support discussion, does not support resolution of cases. Restorative justice, on the other hand, aims to rehabilitate offenders, promote reconciliation with the victims and the community, and this is reflective of informal, traditional African justice mechanisms, which are still largely employed in the resolution of cases. We heard earlier on from the Honorable the Chief Justice that about 95% of cases in Uganda do not go through the formal justice system. That tells you how immense and how important the alternative justice mechanisms are. So plea bargain fills a gap in that arena of criminal justice. And I want to borrow from a statement made by the trial judge in a famous case of Kanyamunyu, Matthew versus Uganda, where the judge observed that the minimum elements of restorative justice require a process in which victims and their offenders meet face to face, and that they come to some understanding which constitutes the outcome that they have determined, and that is through plea bargaining. The legal and strategic framework for plea bargain as an alternative dispute resolution mechanism stems from the Constitution. Article 126.1 has already been spoken to by many of the speakers. I don't want to emphasize. However, courts are supposed to consider the laws, the values, the norms, the aspirations of the people, and these aspirations are expressed through their expectations and through that process of negotiation of their fate in criminal cases. In as far as the cultures do not conflict with the Constitution, they ought to be considered in adjudicating disputes. Now, since the majority of cases are resolved out of the formal system, which is perceived as alien by the people, there is a need to bridge the divide so as to deliver a people-centered justice. Now, plea bargain is formally recognized as one of the pillars of ADR in the Judiciary Strategic Plan 2021 to 2024-5, and is one of the key interventions in improving court processes and case management. Just to understudy the Kanyamunyu case, which is not the only case that has been resolved, but because of the high-profile nature of the case and the public attention that it got, I think is a perfect example of how plea bargain can be used to settle matters and consider or bring on board the alternative justice mechanisms. In that case, a criminal charge of murder brought against Kanyamunyu through the formal justice system was settled through a hybrid, if I may say so. A hybrid because Kanyamunyu, who comes from the western part of the country, from a different culture, submitted himself to the traditional mechanisms of the North, went through the forgiveness and reconciliation portions of ceremonies, and then came back and concluded the trial in the formal mechanism. He was then convicted under the plea bargain for manslaughter, not the murder that was initially charged, and sentenced to 5 years imprisonment. And I think this is just one of the many cases that have seen that hybrid through the plea bargain. The experience from Lango, Acholi, Karamoja, and the Greater North shows that many cases in the formal justice system fail to proceed following their resolution using traditional mechanisms. And this often leads to dismissals for want of prosecution and a waste of resources. And where the cases are not withdrawn by the Office of the DPP, the traditional resolution becomes a mitigating factor to be considered at sentencing. And I think this is what we have to explore. Can the two meet? Can we have a hybrid of the two systems in addressing criminal justice? And I think for plea bargain, that is a possibility. So the objectives are in the rules, and I don't want, because of time, I will not go through them. I just want to highlight the salient features of the plea bargain rules that support the ADR. First of all, the fact that the parties consult the court, and if there has been that discussion where the alternative justice mechanisms have been applied, it is brought to the attention of the court and becomes part of that negotiation process. Now, what that means is that the judge and who has to be consulted about the plea bargain has the knowledge at the back of their mind that another system has already been employed, cows have been paid, some kind of compensation has been given, and so in determining the appropriate sentence can take into consideration what has happened. I think this Rule 5 of the rules highlights the aspect of knowledge. At what point does a person who finds themselves in the formal criminal justice system trigger the plea bargain process in order to resolve his dispute? And if at all, the knowledge that this is a mechanism that is available to them. This emphasizes training, public attention, communication being made so that accused persons can know their rights. And I think it needs to be entrenched in our criminal procedures. The ACD case management rules, for example, of 2021, emphasize that an accused person must be told about the option of plea bargain. Rule 11 provides that the interests of the victim, the complainant, and the community must be taken into consideration, and I emphasize what I underlined, any other relevant information. Now, since the plea bargain rules came into force, the judiciary has undertaken significant training, not only for judicial officers, but also for prosecutors and the defense teams. And initially, the plea bargains were handled in plea bargain camps. And whereas the camps have been retained, plea bargain has been entrenched in the management of day-to-day criminal cases. And so you can have it employed even where there is no camp. Some of the gains, which I think are critical to a people-centered justice system, is the increased resolution of criminal cases through plea bargain, a faster case disposal rates. Statistics reflect that the time spent on remand has dropped by more than half. You recall initially I said up to 8 years one would be waiting for trial. And I want to just give a few examples of the disposal rates. Luzira Maximum Prison alone for capital offenders, that is, in 2022, 240 cases were concluded through the plea bargain. This figure shot to 270 in the following year, and that is just for inmates at Luzira Maximum Prison. I'll use an example of Mbarara High Court Circuit. A plea bargain camp was held in June 2023 with the Pepperdine team. Capital and non-capital offenses were covered, and in the space of 1 week, 532 cases were completed. In November 2023, 2 judges at the circuit cleared 73 capital cases in less than a week, and in December, cleared an additional 46 cases. Now, they disposed of an equivalent of 3 criminal sessions. We have a session system which tries 40 cases within 1 month. They did an equivalent of 3 criminal sessions, which would have taken 3 months in the space of 2 weeks. There is the reduced cost of prosecution and adjudication of cases. The June 2021 Barara camp concluded 523 cases at a cost of about $21,052, which is just above the amount that it costs to run 1 month criminal session of 40 cases. That takes $17,000. We don't know the level of satisfaction or the level of satisfaction of the accused persons to the plea bargain process, because I know that many appeals are filed, but we don't quite know how many appeals, how many of these cases end up in appeals, and probably that is some area that would be good to study. But there is now a growing body of homegrown jurisprudence in the arena of plea bargain, especially from the Court of Appeal, streamlining its application. We have more convicts in prison than remand prisoners, and as of 4th March 2024, prisons are holding 53% convicts as compared to 46% remands. Of course, cases can be fast-tracked once the accused indicates an interest in plea bargain, and committal proceedings can be expedited because they too cause a delay in the system. The interests of the victim, where ascertainable, are being taken into consideration. A few challenges: the question of victim representation. I think this is an issue that we will continue to emphasize, especially with the prosecutors, because the gains are lost if the victims are not represented. But we have, at times, a very low victim turnout, and their views, therefore, don't filter through. It cannot be ruled out that some inmates may opt for plea bargain when they're actually innocent because they are tired of being in prison. We have issues of failure to follow procedure. We have imposition of sentences not agreed upon, but these gaps are being addressed through the training and the circulation. I want to submit that as far as criminal justice is concerned, plea bargain can be a game changer in ensuring that alternative mechanisms are considered in the resolution of criminal disputes. Thank you so much.
The next speaker is Professor Cameron McClung. Okay.
My Lord, the Honorable, the Chief Justice, if I may, I will adopt the protocols as previously established. Thank you very much. Well, greetings to all of our esteemed guests. I would like to again welcome you from all of Pepperdine University. We are so grateful and privileged to be here in your presence. And I sincerely wish all of you could have been present last night at the graduation ceremony, as it was a beautiful ceremony celebrating such great accomplishment. If you were there, you would have also witnessed me attempt to join the dance troupe in the traditional dance, which may have not been as beautiful as the ceremony itself, but it was wonderful nonetheless. Well, again, my name is Cameron McCollum. I am the director of the Sudro Global Justice Institute at Pepperdine University, Caruso School of Law, and I'm an adjunct professor of law at the law school as well. And what I'd like to briefly do is, before talking more about plea bargaining specifically, is introduce a little bit about what the Sudro Global Justice Institute does. Apologies for the technical difficulties, but I think we got it. Wonderful. Okay, I'd like to briefly introduce the work of the Sudro Global Justice Institute, and then I would like to follow up to what the Lady Justice shared about plea bargaining with a little bit more practicality of how our colleagues in the Ugandan judiciary have had such success with plea bargaining as an ADR mechanism. So the Sudro Global Justice Institute is essentially an ADR institute focused on specifically criminal ADR mechanisms, specifically plea bargaining, as the Lady Justice was just talking about. As Vice President DeWalt mentioned in his opening remarks, we all know that that case backlog is a truly global crisis. And if I had to boil down one reason the Sudro Global Justice Institute exists, it is to end the global crisis of case backlog. Why? Why is that? The answer is really simple, and one that all of us in this room are intimately familiar with. It's because that we know that an effective and an efficient criminal justice system is the foundation of any thriving community. When the criminal justice system works properly, our communities are protected from violence, victims are given closure and they're given justice, and the accused receive adequate and timely access to justice. But the opposite is also true, right? When the criminal justice system breaks down, everyone tends to suffer, and that is what case backlog does. Thankfully, this is a remarkably solvable issue, and the answer is what we're here to talk about today. It's ADR. I love what the Honorable, the Chief Justice of the Republic of Uganda shared earlier in his remarks. The United States does, in fact, resolve about 98% of its cases prior to trial through some ADR mechanism, but those principles were born here. ADR should stand for African Dispute Resolution because it was born here. It is such a beautiful part of your culture, and I've loved getting to hear about its roots in the traditional culture. I believe that through the implementation of these long-held practices that we can and we will end the endemic of case backlog in our lifetime. So as we know, I forgot to change my slide here. There's over 3 million people today around the world who are stuck in pretrial detention. This is a great example of what case back looks like. Files upon files upon files. I'm going to keep moving through some of these slides as a matter of time. We've heard a lot of this from some of our speakers, but the benefits of plea bargaining are held across the criminal justice system. Plea bargaining promotes overall efficiency and cost savings, which you're going to hear more about shortly, as our team has been working with PhD statisticians in these case studies to prove out not just, we know the benefit of plea bargaining to the accused, to victims, to the community, to restorative relations and communities, but what is the impact financially of case backlog when somebody is overstaying their time in prison for not just months, but maybe years? There's an economic impact that is very measurable and significant. We know the accused are benefited. We know victims are benefited through expedited closure and protection. We also know that it impacts crime deterrence because it tends to increase convictions for crime as well. Okay, so skipping ahead, what I want to do is spend our time talking about the two different approaches to plea bargaining that Lady Justice mentioned. And the first one is special plea bargaining sessions that happen in the prison. And the second approach is actually implementing plea bargaining into the everyday practice of the courts. And I want to highlight why both of those approaches are critically important. The first approach is this idea of these special plea sessions that are happening in prisons across Uganda. In fact, just about 10 km down the road, there is a session happening in a prison right now all this week where I would assume more than 500 cases will be completed, and it's happening as we speak. There's teams of roughly 40 defense lawyers, law students getting involved, judges, prosecutors, all in a prison right now doing this work as we speak today. And the importance of these special plea sessions is because we need both a reactive approach that is going to address the current case backlog. In some estimates, in many of the countries we work, up to sometimes 90% of a prison population can be filled with remandees. We need a mechanism that's going to address those already there in a timely fashion. And that is the purpose that these special plea sessions hold, is to go into the prisons, to literally bring court and to bring justice into the prisons. And then also, we need a prophylactic approach, which is implementing plea bargaining into the everyday practice of the courts, so so case backlog never occurs in the future in the first place. My colleague, Scott Leist, I'll invite him up momentarily to speak more about this second approach. But what I'd like to do is show you some photos to actually take you into what this looks like on a daily basis and what teams are doing in the prisons right now as we speak. So these photos you're seeing are from a recent plea bargaining session in a prison. And it typically takes place in a courtyard much like this, where we'll have tents filled with every type of criminal justice stakeholder, judges, prosecutors, defense attorneys, who are actually hearing cases live in the prisons, resolving them in a matter of hours instead of months, if not years. So right here you see a photo of many remandees being sensitized, understanding being told what plea bargaining means, what their rights are. This right here is a photo of teams of lawyers interviewing their clients, Ugandan law students, Ugandan lawyers. And then once the clients have been interviewed, they're taken over to the prosecutor to negotiate. The lawyers actually go and negotiate their cases right there live in the prison. After the prosecutors and the defense attorneys hopefully come to an agreement, a reasonable offer. This is a photo right here of prosecutors talking to lawyers and clients. And then after the prosecutors and the defense attorneys agree on a reasonable sentence, a judge is sitting right there in court, hearing the case, resolving the case live, until the plea agreement is eventually resolved. So this is just data from a two-day session that happened about a couple months ago. We had 442 remandees sign up to take place in the plea negotiations. In the matter of 2 days, 96% of those cases were handled, or at least they were given the chance to speak with a lawyer about their case. And of those 96%, so about 400 cases, 224 of them were resolved. And what's amazing is that of those 224 resolved cases, 115 of them were set for immediate release because they had already overstayed their sentence. They'd already overstayed their amount of time. Now, this likely differs from country to country, but I've heard in many countries an estimate for what it may cost to keep a remandee in prison is somewhere around maybe $5 or $6 US a day, feeding, medical care, all that goes into it. And when you start multiplying $5 or $6 per day times months, if not years, you have a very significant amount of money. So that is what's happened. That has been a critical component to the implementation of plea bargaining in Uganda. As we heard the Honorable Chief Justice share earlier in his remarks, Uganda has completed well over 40,000 cases via plea agreements. That is a remarkable number, remarkable provision of access to justice, remarkable service to the community, to victims, to everybody. And the amount of, cost savings that has come from that is significant. And I want to highlight one more significant piece of how plea bargaining has grown over the years, and it's through annual conferences just like this. Every year since, I believe, 2016, we have held an annual plea bargaining conference where all the judicial leaders have come together and we've discussed the challenges, the gains and the challenges alike. We've talked about issues such as, what do we do about time served on remand? Is that credited for somebody in a plea bargaining situation? What about multiple defendant cases? What about appeals? It's been the annual bedrock of how Uganda has continued to forge the plea bargaining program. And in addition to these annual plea bargaining conferences, we've also been able to hold typically an annual delegation visit to Pepperdine's Malibu campus, where we have further unpacked some of these issues, how the program is going to continue to grow. What I'd like to do now is invite my colleague Scott Leist to the microphone. Scott Leist is our East Africa director. He lives here in Kampala and is just a phenomenal lawyer and leader. And so, Scott, please join me up at the microphone. But he's going to talk more about plea bargaining in the everyday implementation of the courts and public defense generally. Down is next.
It is such an honor to be here. Chief Justice, if you would allow me also to abide by the protocols. I think what I'm going to summarize my remarks as, and I apologize, I have a bit of a cold, is what happens when plea bargaining begins to take hold on a daily basis. When you have courts where case resolutions are happening on a regular basis without the need of trial, what does that look like? I've worked in a number of justice systems around the world, and they all have the same problems. They're all the same problems that you justices know very, very well. Too many litigants, too many remandees, cases that get stalled, that back the system up. You have hardworking people who want to move the cases forward, but you have growing populations, you have young populations, who often those are the people that are getting in trouble and ending up on remand. And so you have a lot of effort and a great structure that just gets overwhelmed. Those are the same problems in the United States, which is where I practice. We have the same mechanisms that you do, along with some requirements. We have speedy trial rules in the United States that force us to deal with cases more quickly. Yet we still have a backlog. So these problems are not unique to the United States or to Uganda or to any of your jurisdictions. I would guess that it's a common challenge for every judge that is standing or sitting here. Mr. McCollum mentioned the effects of the special efforts that Uganda has made to advance plea bargaining and resolve cases, these prison camps. The one is happening right now, as he mentioned. They are a regular practice here in Uganda, and they are incredibly effective. They are a bit expensive, however. To pack everybody up and take them to an outlying prison requires transportation and allowances and food, transportation of remandees, courts. So they are incredibly effective, not just to resolve cases, but also to spread the word about how to resolve cases short of trial. But as it becomes an everyday practice, as resolving cases short of trial becomes an everyday phenomenon, resolutions go up, backlogs go down, prison overcrowding eases, and costs actually reduce. So I'm going to talk about one particular place just outside of Kampala that the Chief Justice has allowed us to work in as a pilot program, where we were taking plea bargaining, which initially in Uganda began at the high court level. Uganda took a very aggressive and interesting approach in developing plea bargaining. They started doing it with their hardest cases first, the high court cases, the capital cases. They've now begun to trickle down or implement it more at the magistrate court level. And I just want to talk briefly about what that has looked like. So there's a suburb of Kampala, I'm ahead of myself, called Mukono. This is the Mukono Chief Magistrate's Court. Initially, it was just a handful of judges. Now there's 5 judges that sit in this court, as well as supervise a number of other subsidiary courts. 2 chief justices, not chief justices, 2 chief magistrates, and 3 grade 1 judges at this court. Just in this court last year, our team, the Pepperdine team, and I am the only Wazungu on this team. These are all Ugandans. They're out doing the work. I just chase them around and try and offer them support and tell the stories about what they're doing. They are doing the work. We sensitized almost 9,000 remandees. We reached 9,000 people to talk about plea bargaining. We signed up almost 2,400 clients. Those 2,400 people that said, yes, I'd like you to try and help me resolve my case. Of those almost 2,400 people, this team resolved 1,600 cases in about a year. And of those 1,600 cases that were resolved, 728 were immediately released. I want to say this again because I want everybody to understand it. I have 3.5 lawyers. And when I say 3.5, I mean 3 full-time and 1 part-time lawyer. So these are 3.5 lawyers working in these courts every day over the course of a year, with holidays, with all of that. And these 3 lawyers in one area, in 1 year, resolve this number of cases. The statistic that I want to focus on is the releases. And I want to make clear that I've been a prosecutor and I've been a defense attorney. And I know I heard the president's remarks that were not terribly kind about defense attorneys and our role in the system. They may be somewhat true, but I've been on both sides. I've played the role on both sides. And what I can tell you is that Uganda and the other countries in East Africa where we work, I think, have such a heightened sense of justice. It is not about helping people escape their consequences any more than as a prosecutor, your job is to make sure everybody goes to jail for the maximum amount of time. Those are the 2 extremes. What plea bargaining has done is it's allowed accountability, it's allowed reconciliation, it's allowed restitution. And that initially was through people agreeing to plead guilty, agreeing to take accountability. But as everybody in this room knows, as a practitioner, not every defendant should plead guilty. We've all seen a case file, we've all dealt with litigants where at first blush, it's very clear what should happen in the case, but as you begin to turn the pages, or time goes by, you realize that this may not be as simple as you believed. Investigations are sometimes imperfect. Witnesses lose interest. Memories fade. Parties reconcile and resolve. Evidence changes, and new information comes to light. And that is where the evolution of simple plea bargaining has turned to more of a public defender or a defense advocacy model. And what's fascinating about this model is, like I talked about the roles earlier, that prosecutors have this reputation of being people that want to put everybody in jail for the maximum amount of time, and defense attorneys have this reputation as being people who want nobody to go to jail at any time. What we've found as we've worked together in Makono to resolve these cases is that the parties have begun to trust each other. Whereas initially, where my team of lawyers would go and talk to prosecutors and say, I think you've got some challenges with your case. I've talked to your witnesses, and they're really not interested in coming anymore because there's been a reconciliation. Or I've looked at the evidence in your case, and you've charged 5 people, but there's really not a very strong case against number 4 and number 5. Initially, they would say, well, I'm not interested. I don't believe you. We're adversaries. What we should do is go to trial and flesh this out, which leads us to the same problem we have before of the case doesn't go anywhere. It sits in the trial queue waiting. What happens as we've built this trust and we've worked together and we've resolved these cases is, and the parties know each other, is that we're able to resolve those cases without necessarily a guilty plea. Sometimes cases are reduced, the charges are reduced when prosecutors identify issues. Sometimes the parties reconcile. There are situations where, because the team of Makono lawyers get in front of the prosecutor realizes there's been 3 adjournments in this case. I should just dismiss it because it's not moving forward. That would never have happened 2 or 3 years ago because we hadn't built the trust between the parties that we could work together while also working with integrity within our own silos. Which brings me to perhaps one of the most important numbers that is not on the screen. Last year we had 205 cases that we resolved either by agreement or by dismissal. That means that of those 1,200 cases, of those 1,600 cases, 200 of them went away. Not without consequences, not without accountability for many of them, but they went away because the parties realized when they sat down to talk about a resolution that the parties could resolve it. So 205 of those cases resolved by dismissal. The system has been so successful just even in this one court with this limited number of judges that with the grace of the Chief Justice, he's authorized to move into some other areas around Kampala. We've begun in a court called Nakawa, which is a bigger court and a closer court to Kampala and a busier court with more magistrates and chief magistrates. The other thing we've found is plea bargaining. I come from a common law jurisdiction, which is the same as Uganda. Plea bargaining is pretty easy in a common law jurisdiction because you're fighting about the crime, and then if you need to fight about the money, you can do that separately in the civil system. It's a little bit more of a challenge for some of you that are in common law countries, where the criminal and the civil law countries, where the criminal and the civil resolutions are tied very closely together. What we've learned through work, and I'm grateful that Justice Mutabasi is here from Rwanda, what we've learned through working in Rwanda over the last year and a half or so is that plea bargaining can also work in a civil law context. It's trickier. You obviously have to be careful because the resolution encompasses more than just the criminal case. But since 2022, which is when Pepperdine signed its MOU with the Rwanda judiciary, we have resolved, I've seen the numbers today, I think it's 6,600 cases in Rwanda through plea bargaining. Every region, 12 intermediate courts, 30 districts, 41 primary courts in about 18 months. And I suspect that what is going to happen in Rwanda is similar to what's happened in Uganda. While initially it is guilty people wanting to plead guilty, what I suspect will happen is as defense attorneys and prosecutors work together, kind of in their own ADR system, in the criminal system, as they work together, they're going to realize that they can resolve cases as well through kind of a public defense model. Putting these statistics before all of you is risky. This is a group of judicial leaders, your decision makers. You think about budgets, You're here today because you care about your countries and you care about justice for your people. It's why you got on airplanes to come here. It's risky because you know what these numbers mean. And I already spend a lot of time on airplanes. So, but I want to volunteer, I want to say a very dangerous thing to all of you, and that is that Pepperdine stands ready to help you. Pepperdine stands ready to partner with you. We don't go where we're not invited. We don't force our way in. We don't claim to have all of the answers. We have a little bit of knowledge and a little bit of experience, but we have a lot of enthusiasm and we have a lot of on-the-ground knowledge. And so I commit to you that if there's a way for us to help you explore how to expand opportunities in your countries, I stand ready to help and talk about that. And in that light, I'd like to turn it over to my colleague from West Africa in Ghana, where Pepperdine has begun initiatives there and in other countries in West Africa. His name is Alan Collier. Thank you.
What's my first slide? Oh, we lost it.
Hello, everyone. It's a, it's a great honor to be here. I want to thank the Honorable Chief Justice and ask that if it's okay to observe all protocols. And the Honorable Chief Justice from Southern Sudan. I also want to greet you from the Office of West Africa, and particularly my friends from West Africa who are here today, particularly those from Ghana. And I just want to say, going back to 2019, the person who would become the president of Pepperdine University, Jim Gash, was invited by the judiciary of Ghana to come over to Ghana to send a team to talk about how we might interact on plea bargaining, because the seeds of plea bargaining were already happening. And we were blessed that the US Justice Department, who has somewhat different sort of motivations than we do, some of which are because they found in West Africa that terrorist organizations are actually pulling people out who are in prison too long and recruiting them out of prison by saying, hey, I'll pay your bail if you'll help me out. So there's a lot of things just on safety of a region, et cetera, that the US Justice Department was already interacting in plea bargaining. So they asked us to start talking about it. But as my colleagues from West Africa would tell you, West Africa and East Africa are different, just like all the nations here are different. So there's different pathways to get to the same place. So in West Africa, what was decided, at least in Ghana, was that they wanted to have actually amend the Criminal Procedure Act. And let me see, where's my... So they wanted to amend the Criminal Procedure Act, but when you do it that way, it takes some time. So when we got there in 2019, all of a sudden COVID happened, and then it took some time to work plea bargaining legislation through the legislature of Ghana. But that was passed in June of 2022, and so we're very happy to have a plea bargaining law in Ghana. But now we're talking with the CJ, and we're talking with the DPP, and we're talking with the Attorney General about what's the best way to implement it. And so as you go on different pathways in different countries, we try to find the pathway as we're waiting for plea bargaining to get passed. What's the pathway of helping it get implemented the best? And to have the best way of plea bargaining get implemented the best, you need to have a public defender. Public defenders in action, like Professor Lice was talking about. So, so what we did was, and I'll go back to this one. So what we did is when we got there, there was a Legal Aid Act in place. So the Legal Aid Act of 2018 actually said in the legislation that a public defender division should be part of legal aid. It should be the focus of legal aid. So the Chief Justice of the time, Chief Justice Yeboah, and the head of the Legal Aid Commission, who was a Supreme Court Justice, Amagacher, asked myself and asked the representative from the US Justice Department, who is based in Accra, to sort of interact with them and see if we might set up a way to get that going. So what that led to was us developing a public defense steering committee where we were starting to do things. And some of the things we did was we toured around the whole country of Ghana to see what was going on in legal aid. You know, what were they doing? What were they actually doing every day? And what we found is there was a lot of focus on civil law at the time, doing divorce cases, things like that. There was very little efforts as far as defending criminals, when in fact the legislation said we should do that. So when we got all that data, we started taking that to the board, et cetera, and then we started training in criminal law to all the legal aid lawyers. So this is a good example. The gentleman to my right is a public defender from the federal system in the United States who came over for a year, and together with me, we started training people in criminal law. Another thing we did, and I think we have a photo of this, is that we had Dr. Singh come out, because what we decided to do is if we have so many people handling civil actions, we need to have those really dealt with through ADR, you know, civil ADR, not using lawyers, and take the lawyers and focus them on doing criminal law. So we did a lot of training. We went around the country. And in March of last year, we were able to launch the Public Defender Division. Is there a photo of that? Okay, so this is the launch of the Public Defender Division, which was a big deal in Ghana. And what we were able to do is we were able to, and if you see the lady to the right, you know, 4 from the left, that's Rachel Rossi from the US Justice Department, who's a Pepperdine graduate, who came out and we launched it. We got a lot of public attention. And now we're training the public defenders on how to be criminal lawyers. And that's happening through mentoring by the US Justice Department as well as Pepperdine. It's done through training. And now I'm happy to say today that 70% of the lawyers in legal aid are doing 100% criminal defense. And that's a big deal. Now, it's still not enough lawyers for the whole country, but we're building it and we're kind of showing how it works. Now, because of that, we're getting calls from other countries. And to talk about the difference between nations, Ghana has a very low remand rate, but they have a lot of people out on bail. Lagos, Nigeria has about 85% remand rate. So there's a different approach to wherever you are. Lagos asked us to come in and actually look at their justice system and create and sort of interview everybody who's involved. It was a little bit, and they called it this, bloated. It was different people doing the same thing. And they asked us to come up with a change model that would help them give better access to justice in Lagos. And so we created a report, and we're going to walk them through that this year. And as part of that, it's going to be rolling out plea bargaining, because they had plea bargaining in Lagos, but they didn't have, they needed a little help getting creative about how to implement it. So some of these ideas that Scott was talking about are things we're going to be starting to do in Lagos. So with that, because I said I have the power of separating you from your lunch, you know, I just want to say, very happy to be before you, but just wanted to give you a sense of what's going on, because we were also, in 2 weeks, I met a new friend from the Gambia while we were walking around at tea time. We're going to be in Gambia in 2 weeks because the Gambia has called and said, hey, we have a new plea bargaining law. We'd love to have some help with that. So as Scott said, we are here. We're happy to help as we can. And we realize that every nation has different things that they do well and different things that they have need for. So we're ready to be creative and help create the pathway that is best for you. So thank you very much.
I have been advised that it is good for us to go for lunch. I think it is a good advice. When we come back, I don't know how long, 30 minutes or so, we come back, and then we resume the discussion with the 2 Chief Justices and then the others. Thank you.
Thank you very much. We shall request that our panelists, please, you take your seats. My lords, we are going to have lunch. We believe that it's important to have this lunch. Then we shall resume with the session. I would like to request protocol to lead the Chief Justices to where we have prepared their tables. And then we shall be following in that order, as another team will be also picking you from where you are seated to usher you to the restaurant where we are going to have the food. We want to do this as fast as possible so that we can come back here by 3. So strictly we have about 40 minutes, and I think that's sufficient to have something to eat, and then we return. Thank you very much, my lords. Protocol, please, can you come and take our Honorable Chief Justices? As other protocol teams also from behind, you can be ushering in our guests. Points. Protocol, let us have the guests back. Your Worship Chemeri, Pamela, Conrad, and the team. Peter. Once again, our chair for the continuing session is already seated, and I would like to redeem the remaining minutes so that we can conclude the remaining sessions. As soon as the Honorable Chief Justice of Uganda is back to their seat, we should be commencing the session.
Thank you very much, PRO. My Lords Chief Justices, allow me make just quick announcements before we continue. For the next session, we are having one discussant, the Honorable Chief Justice of Botswana. The Honorable Chief Justice of Uganda said what he already presented will suffice so that we redeem the time. So once I finish, I'm handing over to the chair. But just to know that the next program is for all of us, the next session, but the last one for today is going to be only for the Chief Justices. So after we are done with the session that is going to be chaired by Honorable Chief Justice David Maraga, the rest of us will leave, their lordships, the Chief Justices, to continue. My Lord Chief Justice, South Sudan, I hand over to you to sum up this session in about 10 minutes. Thank you.
I think Honorable Chief Justice Alphonse is not around. I think he has taken permission. Okay, I was told. Thank you, my brother. We have only two of them, and I'm told that because we have another session after this, each one is to be given, each of the two Chief Justices is to be given 5 minutes. And then I said I will have to give myself 2 minutes to hand over to the rest. Now I call upon my brother, Honorable Justice Alphonse, to react. Yes. You can come. My brother, Honorable Justice Terence, you are requested to come in front here, or you prefer to talk where you are sitting. But if you come forward, it would be better so that you are seen by your brothers and sisters.
Thank you, my Lord Chair, my Lords, members. In addition to the remarks I made this morning, I'll just add little to bring out what the position with regard to ADR is in Uganda, to be able to mainstream ADR as a robust justice system. First of all, the Constitution of Uganda 1995 provides in the preamble. Now, the preamble with its objectives have been, through an amendment of the Constitution, made part of the main body of the Constitution. It still remains with the title preamble, but it's now Article 8A of the Constitution. What this means is that the provisions in the preamble, the objectives contained therein are now justiciable. They are not only advisory, they are not only a matter one to look to give meaning, but they are now justiciable, just like the other parts of the Constitution. Now, the Constitution provides for the application of customary law, but it retains the old tradition introduced here in 1902 when English law was introduced in this country, that customary law is applicable subject to it not offending, subject to it not being repugnant or contrary to good conscience. Now, what is repugnant, what is good conscience is a matter of looking at each customary law and interpreting. Of course, one can go deep into this. This is not the time for doing that. And then the Constitution of Uganda provides that the judiciary, the justice system here, is done for and in the name of the people. That makes judicial officers delegates of the people. So the justice we render, the adjudications we do, is in the name of the people. Then, of course, the other provisions I mentioned in the morning, the aspirations, the values as governing principles when we are applying the rule of law or when we are interpreting the Constitution or rendering justice. Now, in this country, a number of legislations and rules are in place which really promote alternative justice system. I've mentioned the Constitution. Then there is the Arbitration and Conciliation Act, the Judicature Act, from which stems the civil procedure rules, commercial court division, mediation, pilot project rules, the judicature, commercial court division mediation rules, and the judicature mediation rules. These are statutory instruments that seek to entrench, to put in place guiding rules for the application of alternative justice system, which I talked about this morning. Now, Uganda applies both criminal and civil alternative dispute resolution mechanisms. The more popular, the more successful one, again, thanks to Pepperdine University, with whom we've collaborated for the past 15 years or so, is in the criminal justice system, the plea bargain. The plea bargain has opened up our eyes to the usefulness, the importance of alternative dispute resolution, where an accused person who knows they're in the wrong comes forward and says, yes, I did this, I take responsibility, and then negotiates the punishment. And the complainant or the aggrieved family or persons are given an opportunity to say a word, at the end of which the judicial officer now carries out the process of plea taking, and conviction is entered, and sentence is passed or imposed. We have on record that for several thousands of cases, I forget the figure now, as little as 10,000 billion Uganda shillings was spent. Whereas if we had gone through the traditional trial system, the adversarial one, we would have spent 35,000 billion shillings. Meaning, we saved 25 billion. For the same number of people, 25 billion rather, 25 billion. We saved 25 billion, we spent 10 billion, we would have spent 35 billion. This is because of the plea bargain process. In the criminal justice also, compensation is emphasized as an alternative to imprisonment. The sentence bargaining is for all criminal cases, capital to the most petty of offenses, involvement of victims or complainants, encouraging diversion, especially in relation to juvenile offenders, promoting reconciliation, which is really important for society, as I pointed out in the morning. Promoting community service orders, where an offender, a convict, is sentenced to rendering community service where he comes from as a form of punishment. This is normally in areas like domestic violence and personal offenses, unless, of course, they are too grave. Encouraging payment of fines, especially in relation to property-related offenses. And then in civil suits, we're pursued, again, quite robustly, small claims procedure courts for matters that do not exceed 10 million shillings. It is a cheap, expeditious, and meaningful way of resolving disputes without involving lawyers. So one avoids the cost of lawyers and yet gets justice. arbitration of commercial and other contractual disputes, mediation of all civil disputes, and we have introduced appellate mediation. Only a week or so ago, the Deputy Chief Justice who heads the Court of Appeal / Constitutional Court resolved on appeal a long-standing dispute, and the parties went home happy. Now, I have appointed a 9-member committee. Thank you. Excuse me. I've appointed a 9-member committee chaired by the Honorable Deputy Chief Justice, who is here with us, to spearhead the AJS strategy, alternative justice system strategy, and pave way for the future. Only the other day, the Minister of Justice, Constitutional Affairs, who unfortunately is not with us because he had to fly out of the country, presented before Cabinet information paper on this ADR summit. And what it reports to me is that Cabinet was unanimous, was thunderous in embracing ADR, and they've urged him to come out with the policy soon so that we can go into legislation and so on and so forth. Now, this committee, chaired by the Deputy Chief Justice, as the core members, the lady and gentleman who graduated yesterday with masters in dispute resolution and certificate in international commercial arbitration of Pepperdine University. Pepperdine University has also graciously helped us to train some 40 retired judicial officers headed by Principal Judge Dr. Yorkamu Bamine. His colleague is here. I've seen also David Wangutusi. David, where are you? Yeah, he's there. These are retired judicial officers who are victims of the early retirement provision in the Constitution, where somebody retires at 65, and yet in Africa, 65 is when you begin now to be useful as an adjudicator. So we are bringing them back. They've had training together with other judicial. I've seen Honorable Justice Kania, Augustine, yes, and a few others. Now we are utilizing them to promote ADR in the civil dispute area, commercial division, land disputes, and so on, so family disputes, and so on and so forth. So while we wait for the policy, the law to be in place, within the legal provision which we have, we are employing these people who have had the training. So for the moment, in addition to what I said in this morning, that is the situation that obtains in Uganda. Thank you.
Good afternoon, honorable colleagues. Let me just say all protocol is observed. I'm the last speaker, and we are from lunch. Obviously, the interest in my paper will not be as robust as I would have wanted to. In any case, the previous speakers have traversed this area, the type of issues I was going to talk about, and they gave them justice to those topics. So I'll be very brief. I don't want to spoil the good work or the good presentation already shared with us here. Other than to quickly point out that as a country, we have two legal systems consisting of Roman-Dutch law system existing side by side with customary law. The Roman-Dutch law system, a common law, and we need to be trained in order to fully appreciate it. The customary law is quite easy to understand. It's part of our tradition, our culture, and you don't need lawyers to appear before a customary court. And this type of courts, they're all over the country. There's no place where you can find a chief, a headman, or some elder who would be able to resolve disputes, minor disputes between citizens. And that's the type of court where people really like to go. It's not the same as common law, and it's based on the restorative system of justice. They conciliate people, they reconcile people, mediate, and they're like arbitrators. But the biggest challenge impacting on customary courts today is that lawyers are not allowed there, but people, litigants before those courts, are allowed to engage courts if they appear in common law courts. So people who are really maybe guilty or want to delay cases, they will just pronounce in open court that we want to be engaged by, we want to be assisted by a lawyer. And when that happens, the chief or the court president will have to pause the proceedings and allow the litigant to go for, to have his case registered at the common law courts. Another difficulty about these courts, another challenge, is that they have very limited jurisdiction. They could be helping a lot, but the jurisdiction is quite limited. We have also embarked on a program called Court Annex Mediation. It's a mediation program that we adapted from the courts in Arizona. We have already undergone legislative reforms. The legal infrastructure is there. What you are going to need next is to get a mediation consultant to come and do some training, put in place resources, human and equipment and everything. And then we'll be running. We are expected to be running next financial year. With regards to alternative dispute resolution, okay, plea bargaining. We know very little about it, but I recall when I was doing masters that I did it as a course, and it was ironic that it was taught by a lady from Uganda at the University of Warwick. So I never thought I would come across it until today. But from what I heard from the previous presenters, it's quite useful. And going forward, I would like to benchmark and adapt it to our own circumstances back home in Botswana. I don't think I can say anything much. Like I said, whatever I wanted to say has already been said. The Court Annex Mediation was put in place in 2021, and it's work in progress, and we hope that at the next annual meeting of this nature, I'll be able to report some positive things. But thank you for listening.
I think that is the end of our session. But before I hand over, let me just say a word of thanks and a few words. I want to give myself 1 or 2 minutes. First of all, I want to thank the Pepperdine University staff for coming up with this idea of alternative dispute resolutions. This is because the backlog of cases is a reality facing the judiciaries across our continent. So if we find a way of going around it, that would be great. But there are some problems, the way I think, and we need to address them in the future if this is to be a reality in our situations. Let me say first, the judges that sit in the courts, not all of them, or most of them, do not know about the customary laws of the tribes in the country. You have studied law, yes, in the university, you have a degree, but when it comes to some of these tribal conflicts, it is extremely difficult because the judges do not know this. That is why it is necessary to involve others other than the judges to handle these things. 2, some customary laws or practices are contrary to fundamental human rights. Some of them, not all of them. I want to give you an example. In South Sudan, there is a tribe, I don't mention its name. When somebody kills another, the compensation is in form of a young girl to be given over to the family of the deceased. When she grows up, then she becomes a wife. Isn't this terrible custom? There are many more other wrong, bad customs among our tribes. 3, we have 74 tribes in South Sudan. I believe it is the same thing in Uganda. They may not be 34, but they are also more. And all have different customary practices, which the judges may not know. And that is why it is important to reach down and see what exactly their customs say. 4, traditional authorities like the chiefs have no way of executing their decisions. Even if the parties make a consent that this thing okay, when it comes to execution, it is impossible. That is one problem you need to take into consideration. What can be done in those circumstances? 5, the death sentence still exists in some countries, although the people of UN keep crying every day, no death sentence. But how can it be abolished? We used to respect life, even when killing a bull in according to our custom. Like you have guests or you have a function, you first of all tell Almighty God, you talk loudly among the people why you are killing this bull, leave alone a human being. But things are now different. Humans are being killed, women and children, this kind of stuff. So this death sentence, we will not lie that it will not continue as far as our countries are concerned. Something needs to be done. Then the next point is that the customer chiefs that handle most of the disputes across the country, they have no way of executing their decisions. The chiefs can decide, yes, do this, go and do this, but how to execute it is a problem. Think about that. The other point, payment of blood compensation as an alternative to sending somebody to prison or hanging him, it is being abused by some people. The rich people, they say, I'm going to pay cattle, what is it? I'll kill you, I'll pay. Is it not a payment of 30 cows? Or even if it is in form of money, there are some millionaires that people can kill, and then the money is paid, it's nothing. So people should think about this blood compensation properly. It is not to replace the death sentence as such. Death sentence is important. It was introduced by Almighty God himself. You know that very well. Customary court decisions are not appealable. That is another weak point. The kind of decisions they make, if somebody feels aggrieved, where else does he go? We must have a law that will entitle ordinary citizens outside there to find a way of appeal. The other point is the decisions made by native courts, because the chiefs are illiterate. They don't know how to write their names. The decisions are made verbal. They are not even written. They don't have records. That is the problem. I don't want to waste your time. I want to stop here and say thank you very much, and I hand over to my sister, Jane, and others. Thank you.
Thank you very much, my Lord Chief Justice. I now request you to take your seats on the lower side, because I'm afraid we will not have a plenary, and I believe what you have raised are part of the matters members wanted to raise in the plenary. I request us to give a very big round of applause to our chair. It has been the longest session. Not very easy, but he has managed it very well. My Lord, thank you so much. Let us also appreciate our discussants, the Honorable Chief Justice of Uganda and Botswana. My lords, thank you so much. And let's not forget to appreciate the panel presenters who presented before we went for lunch. Let us appreciate them as well. We agree that we are struggling to manage time together, and the 1 hour we lost, we have not redeemed it yet. So we are going to go into the next session, which will wrap up and be the end of the day for the rest of us, and then the Honorable Chief Justices can have their roundtable discussion. So without wasting time, I invite the next chair, who is none other than the Honorable Chief Justice Emeritus, David Maraga, who is going to take us through preparing for the future, positioning Africa in the ADR world, private practitioner perspective. My Lord, karibu sana. I wish you the best in your 1 hour that you have. Thank you.
Good afternoon. May I request the panelists to please come up front? Please sit down, take a seat. Take a seat. The Honorable the Chief Justice of the Republic of Uganda, the Chief Justices present here, my lords, permit me to stand by the protocols already established and say all protocols observed. Good afternoon once again. I am here on behalf of the African Judges and Jurists Forum, which is a network of eminent judges and jurists across the continent of Africa, who are committed to the promotion of the rule of law and the development. It is a forum that is led by eminent retired Chief Justices and some serving judges, and their focus is on the rule of law. The rule of law, governance by the rule of law. Access to justice, which is what we are discussing here, is a major component of that. And as the presentations have shown, it is actually the core system to access to justice. This conference is therefore a wonderful opportunity for us to get very, very important perspectives as we focus on the rule of law and work together, hopefully work together with the rest of the judiciaries. And I want to thank the organizers of this forum for inviting us to this conference. My lords and the delegates here present, we have had very very powerful presentations. Very, very powerful presentations have been made this morning and some this afternoon. And we are quite grateful to the presenters. I was keen about the presentation by Professor Singh. Is he here? He's not here. If you meet him, please tell him, if he meets me, let him not kneel down before me. Where I come from, I will have problems with that. As I said, we have had very powerful presentations today. The Chief Justice of Uganda made a very, very elaborate presentation. And what among the highlights I picked from his presentation is that it is actually a misnomer to refer to traditional and other forms of justice as alternative. They should be the primary forum for resolving the disputes, and we must accept that. We must accept that as the primary system of resolving disputes. Why? Because other than is it Kenya, and to which we only have 17% of the cases going to the formal system. The others, and the literature I have globally, is that more than 90% of the disputes do not go to courts. Then how do you now call the systems which are handling more than 90% as alternative? Thank you very much, Chief Justice, for that presentation. This afternoon, the topic of this panel here is preparing for future, positioning Africa in the ADR world and we are going to look at it from the private sector perspective. We all understand, we all know the role of the private sector in our economies. In Kenya, we have a division in the High Court which deals with commercial disputes, to which has been assigned, Justice Ngugi, correct me if I'm wrong, more than 5 judges in that division, and they just can't cope. The backlog there is quite high. That tells you why it is so important to resort to the primary, I don't want to use alternative, to the primary systems of resolving disputes. So this afternoon we have prominent scholars and practitioners who are in the private sector and who are handling a lot of these disputes. So we are going to benefit from their presentations so that we know what they are dealing with. The first one, on my extreme left, is Mr. Supo Sashol. Sashol is a senior advocate in Nigeria and a founding partner of one of the leading firms in Nigeria. He has been involved in the ADR systems for over 3 decades. He is a fellow of the Chartered Institute of Arbitrators. He's a former Attorney General. He has practiced in quite a number of areas. He's an advisor in areas of energy, electricity, infrastructure, and quite a number of other commercial areas. And he brings with him a lot of experience. Next to him is our sister, Professor Catherine Rogers from Pepperdine University. This is a scholar in international arbitration and professional ethics. She has been involved in commercial arbitration for a number of years, and as you know, Pepperdine University has done a lot to promote alternative dispute resolution mechanisms in quite a number of African countries. Thank you, sister, for finding time to come and be with us. The one next to me is a senior lawyer and a friend of mine from Kenya, John Oaga. John Oaga is the managing partner of Tribo OK Advocates in Kenya, one of the leading firms in Kenya, dealing with a lot of commercial disputes. He has been in international arbitration for over 20 years, and he brings a lot of experience. His most recent appointment has been to the governing board of the International Council for Commercial Arbitration, and previously he has been in the Nairobi Center for International Arbitration. So these gentlemen have quite a lot of experience to share with us this afternoon, and to manage the time that we've been given, we are not going to follow the program as it was laid down. After discussing with them, they have themselves, I'm not imposing that on them, we have all agreed that we have some form of interactive session. So I'll pose a few questions to them, and in the course of answering those questions, they will bring out what they were going to bring out anyway. So to start with our brother from Nigeria, please come over and let us know, tell us your experience and journey in ADR in Nigeria. We are getting experiences from various jurisdictions. Give us the Nigerian perspective. Brother Shisol. Thank you.
Thank you very much, my Lord. I'm going to hold on to all the protocols dearly before I make a mess of them. It really gives me a lot of pleasure to be here. I was really enamored when I heard about the topic, and I'll answer the question that my Lord has put to me about the journey of ADR in Nigeria. But I thought it was important for me to say, first of all, it's almost counterintuitive for a lawyer who was brought up in the common law tradition to see judges talking about policy. We were told the judges would just decide cases, and it's really bold. But the truth is that the judicial policy of a nation, of a continent like Africa, is absolutely important, so that we can have a compass, a direction, a guide for which the philosophy of delivering justice will be to the people. So I must commend the Chief Justice Summit for this. And my Lord mentioned that I was Attorney General. If I had known about Pepperdine University and the work they do when I was in office, I would have probably made a better job of it. So I really thank you for what you're doing in the ADR space. It's wonderful. Well, let me start with a quotation that I really like. It's a quotation that's taken from a mediator in a live, real mediation case. And obviously, because of ethics, I can't tell you the case, and I can't tell you the name of the mediator, but it's a real quote, and I like it. And then I'll tell you what I want to say. Litigation, he said, destroys people. You need to see them when they walked into this room. Both parties refused to talk to each other, including their managers. But when the mediation session was midway, they both laughed and started speaking pidgin English. They both apologized to each other while reminiscing about the good old days. You could see the relief on their faces. When the mediation session ended, they hugged. They both canceled their engagements for the following day and scheduled a time on the second day to just come in and conclude the terms of engagement, the terms of agreement, and sign it off. And the phrases there are very simple. They reconciled, they hugged, they were, first of all, suspicious of each other, probably even total animosity. But this is the beauty of ADR. So in 1999, actually, I checked, there was no court-annexed, dedicated ADR center in Africa, as recently as 1999. In 2002, the Lagos multi-door courthouse opened its doors, and it had 6 cases. Now, it handles an average of about 3,000 cases a year. And Lagos, you have to understand, in the context of Nigeria, is easily the busiest litigation jurisdiction. 3,500 cases are filed every month. And so you can imagine the backlog. I don't even want to tell you the figures. So when I got into office in 2007, I inherited the Lagos multi-door courthouse. I didn't found it. My predecessor founded it. But I went the distance of institutionalizing it, and the results have been wonderful. And the law that we passed to institutionalize it created a concept called an ADR judge, which meant a designated judge had the duty of combing the cases for cases that could be compelled to go to ADR, to go to mediation. And you must go. It was an order, it was literally treated as a court order. You are not forced to settle, but the opportunity is there. And on top of that, another innovation was introduced in my term called the Lagos Settlement Week. In that week, no courts sat. The whole focus of the week was settlement. And leading up to that week, the judges would have singled out cases that were going to be brought forward into that week. And the week started off a week a year, and now I understand it is 3 times in a year there's a settlement week. And the results are enormous. When people know that the only thing that you're there for is to settle, and the focus is there, it's been wonderful. I don't know whether these things exist in other jurisdictions, but this has been our journey. So this has been our journey, and we're still at it. You know, I was talking to John earlier on today. We are sold this narrative that, oh, there are 86 or 89 arbitration and ADR centers in Africa. There's just too many of them. Why? We don't even know who to talk to. Why are there so many people duplicating? It's a lie. There are 1.4 billion people on this continent. 86 is a drop in the bucket. Please continue to set up centers. Anybody who desires to. We can't get enough of it. Thank you very much. Because in Europe, there are only 700 million people, and they have well over 700 ADR institutions. In fact, they'd been setting up ADR institutions while we were trying to get independence. We were battling with each other, trying to get independence and freedom fighting, trying to release ourselves from the yoke of colonial government. My Lord, I don't know how long I have to answer, but this is our journey. I have a lot more to say as far as where we should go, but this has been our journey so far. The ADR centers are now dotted across Nigeria, and I would encourage the proliferation of ADR centers until we are able to show that we have a better recourse to justice than that which we were forced to take. Thank you.
I'll come back to you, Mr. Sheshol. The next one is Mr. John Ohaga. Mr. Ohaga, you've been in arbitration for quite a long time, especially in Kenya. Please come and tell us how impactful it has been in Kenya and what you see as the... No, just answer that one, then I'll come to the second one. Thank you.
Good afternoon, everybody. Let me also express my pleasure at being here. And thank you very much, Chief Justice. I was here last year and I enjoyed spending the time with you immensely. And thank you for inviting me once again. You asked specifically about my journey in arbitration. I think that's significant for me because to be standing here this afternoon addressing well, it's not a room full, it's a tent full of judges, is significant because I remember very clearly when I first applied to a judge to stay the proceedings so that I could take a matter to arbitration. And the judge was not very pleased with me. And the judge said to me, Mr. Ohaga, Chief Justice, I'll adopt your African dispute resolution. In fact, I think that's even more appropriate. And I want to thank you for that. So there has been a fundamental shift. And what that has done is to enable our jurisdiction, Kenya, I think, to be able to make the transition from seeing litigation as a primary forum for dispute resolution. Without the data, we would never know that, in fact, litigation accounts for less than 10% of the disputes. It is when we began to explore other forums for dispute resolution that we were compelled to actually look at the data and to recognize what the data said to us, which is that litigation was really one narrow, in fact, doorway. And so I'll just segue to mediation, because that led us to considering mediation. And mediation is important for me because I was involved in conceptualizing mediation as a formal methodology for justice delivery in Kenya from the outset. In contradistinction to arbitration, where I had met resistance from a judge initially, when we began to look at mediation and to try and map out the potential obstacles, it is interesting for me that one of the primary obstacles that we recognized was that lawyers would be one of the obstacles, because lawyers would see mediation as very quickly taking control away from them in respect of the way they relate with clients. And you know the concept of accelerating decline in revenue, which is often talked about. But I think today lawyers have begun to recognize that the quicker we're able to turn around cases, the better. So there has been a very significant shift. And I want to thank Nigeria, actually, because we did borrow a significant amount of our learning from the multi-door courthouse in Nigeria when we were considering the various forums for dispute resolution. And so I hope that has gone to some extent to answering your question. Thank you very much.
Thank you very much, Mr. Waga. That tells me in 2020, 1st of July, I was Chief Justice and I introduced the e-filing system. The greatest opposition I had that time was from the lawyers. They didn't want, they said, look, we want to go to court with our clients. So how can you take away that great opportunity? These days when they meet me on the streets, they said that one of the greatest things I left behind is the commencement of use of ICT, and with the virtual hearings, now they are able to deal with their cases from the comforts of their offices and even from their homes. Thank you very much, Mr. Waga, that the lawyers are now embracing that, and it's important that the judges hear that so that they can encourage lawyers to settle. Sister Rogers, Professor Rogers, you're a specialist in international arbitration. What is the difference between ADR that we have been talking about today and the international arbitration? Please.
Thank you. And I will also avoid trying to comply with existing protocols other than to just adopt them, because I would surely mess them up. Other than to say thank you all for having me. I've learned so much today and just found it fascinating. But I am a little different than everyone else here, at least in what we've been discussing today, in that I don't do much domestic of anything. I do international commercial arbitration. And there's a saying by a very famous international arbitrator that international arbitration is to domestic arbitration as seahorses are to horses. They look a lot alike, sort of in profile, but they live in totally different environments. And in fact, they have very little in common biologically. So I'm going to both endorse and distinguish that view. So international arbitration is also not ADR. We've been talking about all day today how it's not really ADR when we're talking about domestic frameworks. International arbitration is not ADR because it is not an alternative. Parties choose arbitration in international contracts because neither party wants to be in the other's courts, because they come from, as Dr. Singh discussed this morning, from radically different legal cultures. And so a Japanese investor doesn't want to be in Nigeria's courts, and a Ghanaian investor doesn't want to be in Brazilian courts. So they go to an international, presumably neutral, playing field called international arbitration. Here are a few ways it's very different. In international arbitration, almost always there are 3 arbitrators. Each side appoints their so-called party-appointed arbitrator. Why is this so essential in international arbitration? Because this way, each party is sure their legal culture, their perspective, can be represented on the tribunal. And then the 2 party-appointed arbitrators together choose a third. And I think that that's an important distinction. And one other distinction I'm going to point out, and then I'm going to argue why maybe they are not so inseparable in domestic and international. Another, and I know all the graduates who got their certificates yesterday in international commercial arbitration know this, one other very big difference between domestic arbitration and international arbitration is that in domestic arbitration you don't have something called the legal seat. Now it sounds very physical, it's like where the arbitrators are sitting. It's not. In international arbitration, the hearings oftentimes are not in the seat, but it has important legal ramifications. And one of the most important features of the seat is that the parties choose the seat, usually a neutral place, and it is the arbitration law, the domestic arbitration law of the seat, that provides the background for how the arbitration will happen in that place. Okay? And even if they relocate the hearings somewhere else, the domestic arbitration law of that legal seat still applies. And what the 2 areas where the legal seats law applies, and it's very important, is it can come in a couple different ways, but one of the most important, for example, is in challenging an arbitrator, in asking for help in other ways during the arbitration. And the other extremely important way is the courts in the legal seat are the only courts that have the power to annul or vacate, these are synonyms, in the language of the New York Convention, which is the treaty that governs international arbitration. They can set aside the award, okay? And that's also a process that essentially you don't need a separate process for recognizing and enforcing awards and setting them aside. In domestic arbitration, those 2 are essentially the same. There's another, and the reason I think that the intersection in the law of the seat is important is because I am very aware of Nigeria's new act. So the Nigeria Arbitration and Mediation Act, relatively newly enacted, was based on the UNCITRAL model law, which is often considered the gold standard for arbitration laws. And it includes both domestic, because those are that's when the court can set aside an award, and international provisions. It's considered sort of the gold standard The other thing that was interesting to me that Nigeria adopted at the same time it adopted its new law is it incorporated in this new law the Singapore Convention on International Commercial Settlement Agreements resulting from mediation. That's important because if you have a successful international mediation, your partner is going to be much more confident that if one party violates the final agreement, that they'll be able to go to the courts that are in a country that's a signatory to the Singapore Convention, and those courts will give effect to that settlement agreement, that mediated settlement agreement. And so this is how, for example, international conventions can interact with domestic processes. I want to say just a few last things before I take up too much time that I think are particularly important for Africa. One is, as was mentioned, I focus on ethics, meaning I don't really study the rules and the laws and the procedures so much, I study the people. And one of the most important things in having a fair and legitimate arbitration is having fair and legitimate arbitrators. And this is a place where I think there's a lot of room for growth for African arbitrators. We've been talking a lot about legal culture. We don't want, you should demand not to have African legal culture not fully represented in the arbitral tribunals who are deciding your cases. Do you know what the region in the world that has the #1 case growth in international arbitration? Africa. Okay. Why? Because there's so much investment here. On the other hand, if you look at the percentage representation of African arbitrators in international arbitration disputes, and you've seen it, right? We've seen disputes between two African parties, and the joke it's not such a funny joke, but the joke in the arbitration community is that most international arbitrators are pale, male, and stale. It's kind of funny, not funny. We're getting a little better, right? Now we have, depending on the year and the institution, around 20% women, so we're working on that male thing. But we are having it much slower to get diverse arbitrators outside of Asia. It's not because Asia is special, it's because Asia's been doing international arbitration a lot longer than Africa. And so I think that there's a lot of work to be done, not only domestically, but also to bring your culture to the international arbitration community so that your culture and also your parties, when they appoint their party-appointed arbitrator, can appoint an arbitrator not only who represents their perspectives, okay, but also has the expertise to be a fully active arbitrator on the tribunal. So with that, I'll stop. Thank you.
Thank you very much, Professor. Let's come back to Mr. Seshore. You were about to start on the way forward. What are your recommendations on the ADR from your perspective and your long experience?
I can truly attest to the fact that I'm growing old when I come into such close contact with senior judges and I'm not in trouble. That means I'm getting on in life. I just want to, my Lord, if I may, and I will talk recommendations in this response, if I could respond to something that Professor said, that Asian countries have been doing international arbitration a lot longer than Africans. See, I'm a bit of a historian, so, it's a passion of mine. The ICSID, the International Convention for Settlement of International Disputes, is the gold standard. It is the central bank of international investment arbitration disputes. The title of the organization says settlement. So I actually prefer settlement because it cuts across both arbitration and other ADR techniques. So conversations around international investment disputes between countries and companies and countries and individuals and countries had been dominating the international sphere since the 1950s and into the 1960s. And they sold this idea that, when I say they, the World Bank community, I mean, call them the global north, the West. They sold this idea that this was going to protect everybody's international investment. No. It was actually designed to protect what was inevitable as Africans were getting their independence, was the investment of those global northern countries in Africa. It was going to protect their investment. Funny enough, the Asians, when they saw the convention, were very lukewarm about it. They were not interested. The Latin Americans were even worse. They were not interested. The people who embraced it were the Africans. In fact, Nigeria, for some strange reason, was the first country in the world to adopt the convention. I don't understand. Well, I do understand because they told them that this was going to guarantee investment into their countries. It wasn't true. So we had been involved in investment treaty arbitration a lot longer than many people, but unfortunately we were always the respondents. We were always the losing parties. And the judgments were against us. Or the awards were against us. Which is why one of my recommendations, I say I got there eventually. I got there. One of my recommendations is to do with the big story, and I'll encroach on John's territory now. On the international sphere, first of all, my first recommendation has to be that this Chief Justice Forum, long may it continue, sir. Long may it continue. It is a brilliant platform, and you are very fortunate. It is very rare that I travel anywhere and I'm the only Nigerian in a room. So you're very fortunate because they're noisy people. So I'm the only Nigerian here. Yeah, that's great. And I'm a bit also surprised that the Nigerian judiciary isn't represented here, and I'm going to have a word with some people when I get back. But honestly, sir, this platform can be the energizer for bringing about what we need in harmonizing our attitudes to ADR, building a subset of minimal criteria of laws that each country should subscribe to encourage ADR across the board. Because ADR is international as much as arbitration is, and it's going to get even more so because of the AFCFTA. So my recommendation number one is that the rapporteurs will come up with some robust recommendations as to the continuation of this forum. It's so important. I really, really have to commend you, sir. Thank you. I haven't finished, sir. Yeah, sure. Just one more. I'm so sorry. No. I'm not used to asking a judge to sit down. But no, the reason why I haven't finished, that would have been a disaster. The reason why I haven't finished is in the AFCFTA, under the investment protocol, and people should begin to familiarize them because it has been adopted by all 55 countries and ratified by over 37, so it is in force. The AFCFTA has an investment protocol, and underneath that investment protocol is the Dispute Settlement Board. There's a Dispute Settlement Protocol, and it sets up a Dispute Settlement Board. It doesn't use the word arbitration, it doesn't use the word mediation, it doesn't settle disputes. And it will be our first in Africa. It will be our first investment body. It is our answer, 50 years late, to ICSID. ICSID, don't forget, we didn't own it. We were told and deceived into joining it so that we could lose cases. Ours will be a homegrown investment dispute body, which will be populated, hopefully, by many of the great legal minds on this continent, most of them in this room. And retirement at 65 will just mean you're just right to be appointed into that dispute board. And it will make sure that the economy of Africa is not disturbed by this growing international commercial arbitration awards that culturally, the rules are not designed for Africa. And many of the conflicts that happen in these cases is as a result of this cultural tone deafness of the panels because, as the professor has said, Africans don't get appointed. The recent statistics released last year by ICSID showed that of all the arbitrator appointments in the world, in ICSID, in the international body in investment arbitration, Africa was the lowest. And the highest in Africa were 1 appointment each from Egypt and Nigeria. The highest, of course, was the United States of America. You know, the World Bank owns ICSID anyway. So you can see that there's a lot of imbalance, inequality that we need to bring in, we need to rein in and control. And it is organizations like this, talking about it, getting our action, getting our acts together, and engaging, energizing ourselves, that I must strongly recommend, sir. Thank you very much.
Thank you very much, Mr. Shishon. Mr. Waga, we've talked about the practice in Kenya. Please, you also give your way forward as to how best we can improve these systems so that we reduce disputes or minimize them.
Thank you very much, Chief Justice. I think I want to echo what Supo said about forums of this nature, because it is only through forums of this nature that we can develop a uniformity of mindset where policymakers, decision makers agree that there is a commitment to achieving specific levels of justice. And I want to refer, very quickly to SDG 16.3, which commits the international community to promote the rule of law at the national and international levels and to ensure equal access to justice for all by 2030. 2030 is only now 6 years, less than 6 years away. So we have a very short time to achieve those lofty ideals that we set for ourselves as an international community years ago. From Kenya's standpoint, the widening of the doorways to access to justice is really at the cornerstone of achieving these goals. And I just want to reel out some statistics which I got from the registrar of the court-annexed mediation program in Kenya, just to give you the strides that Kenya has made towards the implementation of its court-annexed mediation program. As at the end of February, there were over 17,000 cases which had been screened and referred to court-annexed mediation. There were about 15,900, really 16,000 cases which had been concluded with an average settlement rate of 53%, which I think is enviable. The average running days for cases in mediation was 73 days, compared with the average backlog that our judiciaries define. I think that is a really, really commendable timeline. The statistics show that there has been 50.7 billion Kenya shillings released back into the economy as a result of the court-annexed mediation program. There are 1,420 mediators accredited, 751 of them who have an active status, and the judiciary has committed to pay an honorarium of 20,000 shillings per file. So mediators essentially agree to undertake mediation at a significantly subsidized rate. But these are the steps, the strides that Kenya is making towards increasing the doorways, ensuring that there is an opportunity for even those who are indigent to access justice. And I want to add that the access to justice through the virtual platform has really, really accelerated that because we now even have online mediation. So, Chief Justice, I think the future looks bright from where I stand. Thank you very much.
Thank you very much, Mr. Wega. Professor. Sometimes they say that arbitration, I don't know whether it's really arbitration or mediation, arbitrators sometimes behave like some kind of shuttle diplomacy. Please give us an aspect of this, and then tell us how we can promote and build more robust international arbitration.
So thank you. I am definitely not contradicting an esteemed justice, but I will say I'm focusing on international commercial arbitration, not investment, because I understand there are rivals for ICSID. Commercial arbitration is actually quite different. So here we're not talking about, for the most part, claims against a state. We're talking about two private businesses that enter into a contract, and they put into their contract an arbitration clause. And there, the interests and the composition of the tribunal tends to be somewhat different than in investment arbitration. And again, I leave that aside. Interestingly enough, Nigeria was also an early signatory to the New York Convention, which is very different than the ICSID Convention in the 1970s. And in fact, I think both in the Middle East and in Africa, there was a reluctance in many parts of Africa to join in other states to join the New York Convention or the ICSID Convention. But I think it's very important for a moment to focus on commercial, because every year there are less than 100 investment cases. They sort of capture our imagination because they tend to be very, very large, because they tend to be more publicly available, so you see them more. But every year, a rough estimate might be about 12,000 commercial cases, okay, 12,000. And that's a large number to be resolved. And as I said, I study ethics, meaning the people who do this. And if you have 12,000 cases every year, you need a lot of arbitrators, skilled arbitrators, so that parties can have a meaningful choice when they're appointing their arbitrators. And there are many ways that people become arbitrators, but one way you don't become arbitrators, someday just someone says, you're an arbitrator. It actually requires time, usually, a lot like judges, including some I had lunch with today, I can't see them from here. You spend many years in practice, and then you get appointed as a judge. So to be an international arbitrator, you need to be able to spend many years in practice and learning about international arbitration, not just experience in domestic cases or domestic arbitration, and then work your way into being an international arbitrator. And we were just talking about how it's a very closed, historically, has been a very closed system, pale, male, and stale. So how do you break into this somewhat closed system? And this is, again, where I think the people come in. One of the things I've had the absolute pleasure of doing while I've been here is working with students at the Macquarie and the Cavendish universities who are studying day and night to go compete in Vienna in a moot court. It's not a moot court, it's a moot arbitration, the VIS moot arbitration. And they have an energy and a determination that's truly great. But they are much longer, and that's part of the title of this panel, future. What might be a shorter term? One thing I would urge and suggest is that, for example, certainly if you're a state and you have a law firm that's representing you in investment arbitration or commercial arbitration, you can, for example, insist that the private law firm that's representing you, and oftentimes they are foreign firms that have this very unique expertise in international arbitration, that they take a secondment so that your younger practitioners or older who have never had an international arbitration, so they don't have that experience, can get that experience and then can bring that experience back. And so when I say they're sort of shuttle diplomats, it requires a sort of going back and forth between domestic and international practitioners to gain that expertise and to build on that expertise. And part of the reason there's a terrific, since Dr. Singh started with legal culture this morning, there's a wonderful book called The Legal Culture of International Arbitration, written by a friend and esteemed colleague, Juan Kadani, who is originally from Ethiopia. And he tells the story of the risk of not having arbitrators who are African on a tribunal. In this commercial arbitration, again, there was a witness who testified that a certain object was orange, and the arbitrators, who were all Western, non-African, said that they didn't think that witness was very credible, because it says in the pleadings and in every other source that the object was yellow. And as it turns out, and I can't speak to this personally, it's only what I've read in Juan Kadani's book, at least that part of Africa that the witness was from, the word yellow, or the yellow, is ascribed a much broader spectrum of the color scale, and so orange, as he identified it, was actually consistent with yellow, as it had otherwise been identified. Yeah. So it's something as simple as that, right, is a difference in legal culture, something we think of as very concrete, like a color. Couldn't you easily translate that? No, you actually have to have, if you didn't have an arbitrator on that tribunal, which wasn't, to say, no, wait, before you make a decision, before you discredit this witness, let me give you my perspective. So cultural perspectives being represented on tribunals is incredibly important, not only for the right outcome in individual cases, but for the legitimacy of international arbitration. And we just heard someone contesting it, right, because of the low statistics. So I think the response to that, I think, regardless of what happens with so-called investment arbitration in Africa, you are going to have a lot of international commercial disputes. And oftentimes they will choose faraway jurisdictions, okay, as the seat. But you want to make sure that there is at least the possibility of having arbitrators who have experience, sophistication, and who can operate as that, not just as an arbitrator on the tribunal, but as a bridge between the arbitrators on the tribunal and the parties' perspectives. And so I think it means supporting students in the Vismut for the long term. I think it means getting lawyers and sophisticated arbitrators who function domestically more involved in international programs. And this is already happening. I mean, Nigeria has an astounding number of events every year. But I would encourage more and more throughout Africa. And you have great institutions that do not only domestic but international. But as you reimagine your ADR scenarios domestically, I would urge you not to forget and to keep in mind how they can work together to build your capabilities and your strength in international commercial arbitration.
Thank you, ladies and gentlemen. From these panelists, I've gotten 1 or 2 points. I don't know what you got yourself. Mr. Sashol brought out a very powerful point, mediation. It is a healing and a relationship restoration process. That I can testify to. I was a judge of the family division for over 3 years. Family disputes. When you get the family disputants to talk, they will always go out hugging. I don't know about other jurisdictions in Kenya. We have problems with succession, but when you get the parties to talk and say, look, what is involved here is perhaps the division of what the deceased has left behind, they always go out as friends and remain as a family. Mr. Shashol came up with another very interesting perspective. International Investment Protocol dispute settlement. They don't want to talk about dispute resolution, it's dispute settlement. A very great thing which he calls the energizer. For Mr. Waga, he endorses very strongly Chief Justice's proposal that we now start referring to ADR as African Dispute Resolution Process. I entirely concur, and I have nothing useful to add. Professor Rogers, the seat of arbitration. One time I was talking to a government official who signed one of those government contracts which provided the talked of the seat of arbitration being in another country with a different language, with a different system. He said he had not even seen that. And you can imagine the kind of problems that come with that. International arbitration, according to Professor Rogers, is not an ADR. It's not one of the ADR. In fact, she came up with one other system. We have the formal system, we have the informal system, and the professor has said we should also have arbitration. Arbitration as a system on its own. Why? Because it is party chosen and party controlled. Ladies and gentlemen, I want you to put your hands together to thank these panelists for a wonderful. Thank you very much. Sorry, Registrar, we've overshot our time, but I think it was it was worth it. Sorry about that. Thank you.
Thank you so much, my Lord Chief Justice Emeritus. I think we agree that this has been a very interesting session. Let us give him a very, very big round of applause. My Lord, asante sana. You have kept us very alert and we have enjoyed. Let us also appreciate the panelists. I think they also did a great job. Thank you so much. Now, a few adjustments before we allow their lordships to have the final program of the day. My lords, in our program that we have today, the last activity was meant to be a cocktail. But for those of you who were in the High Court yesterday, you agree that we danced and surely got tired. The body needs to rest a bit. So it's been a long day. Let us wind it up and re-energize for tomorrow when we have a cultural dinner where we will dance just as Professor Cameron was saying. So let's reserve the energy that we would have spent in the cocktail tonight for tomorrow evening in a cultural gala. And we need to dress in our African attire. So as many as the flags in the room, it will be good to see all the designs from across Africa. In case you don't have, the markets are open in Kampala, and we can get something so that we are all truly African as we enjoy the evening tomorrow. So with that, this next session is for their lordships, the Chief Justices and the heads of delegation. The rest of us, we will use the next few minutes to step out and allow the chair of that session, who is none other than the Honorable Deputy Chief Justice of Uganda, who will guide on how the different tables or panels are going to be constituted. And the rest of us will be here back tomorrow. 9 o'clock we get started and enjoy the second day and finish well. My lords, I wish you a blessed evening. And as we sign out, my Lord Honorable DCJ, I invite you to take up your chair. Let us use about 5 minutes to allow their lordships remain here as the rest of us step out. As the rest of us go out, the last three panelists will stay as well in the room to support the next discussions. Together with CJ Emeritus Maraga, thank you. Protocol officers, please let's usher out the other guests. The chair of this session is already ready to start. Thank you.
My Lords, the Chief Justices, this summit is actually yours. You may be wondering why others were here, but you lead people, and these were the people you lead. You need to listen to them. You need to know what they think about what the courts in your jurisdiction do. You need to know how you always work with them. So their presence is critical, it is important. We shall have them back tomorrow. We need them, they need you. We are going into the following group discussions. Each jurisdiction will have a table. Table 1 will be Botswana, Benin, and Kenya. They will sit on my left in front here. They will be led by Honorable Justice Richard Butera, myself, and Honorable Justice Gadenya. The rapporteur is Shamim Namyalo. Group 2 is Zambia, Malawi, Eswatini, and Nigeria. Our presenter here from Nigeria, who was alone in the room, and that saved us a lot of noise, shall represent Nigeria. The facilitators will be Honorable Justice Mike Chibita, Professor Andrew Kauka, and the rapporteur is Joy Kahihi. So group 2 will sit at the back of the left row. Group 3 will be Ghana, Sahrawi, and Uganda. The facilitator will be Justice Geoffrey Chiriabwire and Mr. Atoke Francis. The rapporteur is Deborah Namutosi, and the group will sit where the Chief Justice is, middle front row. Group 4 is Tanzania and Zambia. The facilitator is Mr. Francis Jimara and Barbara Yate. The rapporteur is Lilian Guang. Group 4 will sit at the back of the middle row. Mr. Francis Jimara, put up your hand. That's for Group 4. Group 5 will be Zimbabwe, Gambia, and Rwanda. The facilitators are Honorable Justice Richard Wejuli Wabwire and Mrs. Rachel Odoi. The rapporteur is Aziz Chitaka, and the group will sit at the front on my right here. Those are the groups. The facilitators I've read out will come with questions for the groups to discuss. It will be short discussions, and then we'll come back here and, Somalia, I didn't read you out, Somalia. South Sudan is in Group 4. South Sudan is in Group 4. Somalia should be in Group 3. Somalia, Group 3 at the back here. Sorry about that, my lord. Yeah. If I didn't read, Group 3 has Ghana. So that's it, my lords.
You are in which group? Yes, you're in Group 3.